All right, we are recording. So first, as always, I am going to thank everyone, both for attending, for watching this, and for being an active part of our community. As I was saying to people just offline a second ago, if you guys can think of any ways that we can make this forum generally better, please do comment. They are going to help us, no question, in delivering better content and making this more relevant for every single person who's out there. Enough of that. Let's get to why it is you're here. Commissions, and specifically protecting them. Let me start screen sharing. Where's my screen share? There it is. I can screen that. If everyone can just please confirm that you see what I'm seeing, protecting your commission.
Yep.
Okay. So we're going to talk about two things, and I'm dangling the stuff that I know you are going to really want for the very last. And that is, well, what happens if I don't get paid? What are my rights? But I'm going to talk about a couple of things that are very important that you will find very useful as well. You just don't realize you don't know it yet. Specifically about how to protect your commission. So I'm going to basically divide this talk up into two: how to lose your commission and how to keep your commission. And I'm going to start by talking about how you can lose your commission, because actually I've assisted quite a few people in losing their commission. When a buyer comes to me and gives me the following scenario. So let's set the scene. Let's be a bit artistic here. We all have to use our imaginations. We're in the period of COVID. So the scene that I'm setting is that a devilishly handsome lawyer working away at a desk by candlelight. A warm, smiley grandmother of 17 enters into the office, every single line of her face speaking to a lifetime of character. And here's the dialogue that goes back and forth. What can I do for you? And the grandmother says to me, oh, it's just awful. Let me tell you my story. It starts back in 1880. By the way, all stories that a client tell you start back somewhere in 1880, or at least it feels that way. They will tell it to you for 100 years before getting to a point. Partially to coat the fact that it's probably whatever the problem is that they have is not their fault, but it just goes on forever, these stories. And so the grandmother continues and yada, 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 and after about an hour of yammering says, and so given the past 4 hours worth of facts, my realtor is just awful and I don't want to pay commission. My response to that is, great. Here's how we're going to deal with it. So the first and foremost thing that I do as a lawyer to attack agents' commissions are I figure out if, in fact, the relationship between the client and the salesperson is one to which the Consumer Protection Act applies. You'll probably remember something about the Consumer Protection Act based on your time in the OREA law course, but let me show you how it actually directly applies, and I have done this to several agents. So it is the case that there is two different things that can be breached in the Consumer Protection Act: unfair practices or unconscionable transactions. Unconscionable transactions is like, use me as your real estate agent or else I'm holding your dog hostage and we'll kill it. And that's what it would be unconscionable to hold someone and give them commission, given that they forced you to enter into the contract because otherwise the dog got it. That's not as common, although it happens very often in elderly situations where you're taking advantage of people with dementia. That would be where most unconscionable transactions happen. From your perspective, most of the violations that we see in the industry take place with regards to unfair practices. An unfair practice is when someone in the course of marketing their services makes a representation that's false, misleading, or deceptive. And what that means practically is you guys, it does not apply to real estate transactions, but it does apply to real estate professionals marketing their services. So when you go out, Show just joined us, and Show goes ahead and chooses to market his products to a whole range of people. And he says, hey, I'm Show, I'm the best. I have unlimited time for my clients. You want to see something on a Monday, on a Tuesday, on a Wednesday, on a Thursday, I'm always available. Pick me, I will make your schedule work. That's how he markets himself. It's not a very appealing marketing, but that's what he's saying is his differentiator. Now, if in fact show does not live up to those terms, then he has engaged in an unfair practice in soliciting or in getting someone to sign his contract, the buyer representation agreement, in the normal course of things. And accordingly, according to the CPA, the client may write to show and say, thank you very much, I am canceling my contract. This contract was done in violation of the Consumer Protection Act, and accordingly, it has no force and effect. And what will happen practically is the agent will say, screw you, it still is a valid force and effect. And then when you go to court, the agent will say, you have signed a contract with me. Here it is. I'm inducing the BRA into evidence. And what you would say as a defense is, thank you very much. I understand that I signed that, but that contract was vitiated, was voided by virtue of the Consumer Protection Act based on your conduct. And then the trial will pertain to the conduct of the agent. So how do we use this? Well, when I have Show, by the way, Show's an excellent agent. I'm just picking on him. Please don't think that this happened to Show in any way, nor that I've seen him be anything other than the best of agents out there. But I am using his name, so I'm gonna pick on him. When Show goes ahead and says, I could show you Monday, Tuesday, Wednesday, Thursday, and then gets Granny to sign a BRA that lasts 1 year for all of the GTA, in addition to it being an overly broad term, I don't sit there and write a simple letter saying, hey, this is overly broad and is in contravention of the following, it's anti-competitive and God knows what. I mean, that may be true. What I try to do is I try to loop the agent into falling for a breach of the CPA. And before I engage, I basically take over Granny's email and I write a series of emails saying, hey, Show, can you show me on Monday I want to see this, on Tuesday I want to see this, on Wednesday I want to see this. And generally, if you're an agent that is breaching the CPA, you're not the smartest of cats. And what's more, you're a bit vindictive. This is the type of person who generally falls afoul of the CPA. And those people generally write back and say, screw you, I'm not doing anything, I have a signed BRA. Some of them even have said that to me. But most of them say, no, you're being unreasonable, absolutely not. At which point the lawyer's letter comes saying, hey, guess what? You marketed yourself as having the following skill sets and being ready to come out and see property on Mondays, Tuesdays, Wednesdays, Thursdays. Here is a copy of correspondence from my client over the past 2-3 weeks, wherein you have continually denied access to properties and have shown a non-responsiveness that was completely defiant of what it is you marketed yourself as. Accordingly, you have engaged in an unfair practice, and accordingly, we are canceling your contract and we are going elsewhere. At which point, yes, there may be a lawsuit, but there is a defense to the lawsuit. And further, you can make a complaint if you want to the Consumer Protection Act, Protectorate in Ontario, asking them to investigate the agent's deceptive activities. So I just want to point out that you have to be careful. The services you are marketing are services that are challengeable under the Consumer Protection Act. And my big lesson is don't be evil. And the courts will look to your level of conduct and hold yourself out with the highest level of integrity at all times. It's critical. Now let's examine actually what the courts have to say about maintaining BRAs in the first place. Separate and apart from the Consumer Protection Act, there are other ways you can lose your contract that I want to pull your attention to. The first was a small claims court case, but it speaks to a concept called non-est factum. And in this instance, what happened was as follows. A couple comes around and puts an offer on a house that doesn't come to fruition. And in the process, they sign a BRA thinking it extended only to that property. The documents were not extended to the clients. The couples enter into a new build agreement and the agent sues for commission under the BRA. Now, in this instance, the backstory is kind of interesting. I'm not sure if it's this one or if it's a similar case, but one of these cases that was exactly similar to this consisted of a woman who had just given birth. And evidence was induced that at the time that she was signing these documents, she was literally breastfeeding a set of twins that were 2 weeks old. She hadn't slept in God knows how long. she basically, like, she was disheveled at her table and just signing whatever it was. And the agent agreed that this was what happened. And she basically said, I came down, I had crying twins. You know, I was sitting there breastfeeding at the time. I had absolutely no understanding of what's going on. The agent said, your signature's on this. You had an obligation to read this and understand it. And the court said, no, non est factum. This is your signature, but not your deed. It was not understood what was written. And interestingly, just to back up for a minute, you should know I was actually involved in a Canadian case. You know when you go and you rent a car at an airport? You know how you don't just sign one of those contracts? You instead sign something where you initial 6 different places? Well, that happened as a result of a case called Have a Car Leasing. And what happened was a business executive came off a plane once, and ran in, you know, with his items and God knows what, to the airport, Hertz lobby. And basically, they gave him a contract. He signed the contract, and then he got into an accident with a surgeon who sued for like $1 million. And the Hertz, he bought the extra insurance, but Hertz said, thank you very much. There's a term in this 4-page contract that says that your blood alcohol limit has to be 0. The legal limit is 0.08. And his alcohol limit was like 0.02 because he had a drink or something on the plane. He wasn't inebriated. He was well below the legal limit, but the insurance was denied because he had some alcohol in his system. And he said, thank you very much. There was no reasonable expectation of me ever reading this contract. It was never called attention to. And as a result, I am suing you because your exclusionary clauses have no merit. Non est factum, not my deed on that part. And in fact, U-Haul was a case that I was involved in where they basically just took an American contract that doesn't have all those initials all over the place, and they tried to rely on that exact same set of circumstances to say that someone who damaged the hood of the U-Haul was being denied coverage because somewhere in like page 6 of the agreement, which wasn't initialed or anything else, they said this is excluded. And I said, that doesn't work in Canada. And by the way, I'm very interested as to why over the course of 20 years, end user license agreements for Microsoft and others don't work that same way. I mean, how many of you actually read one of those agreements? Is there really actually any person who does? And is there any expectation that people do? Regardless, the point for purposes of real estate is this. If someone doesn't have this properly explained, if you can prove that to a court, then your BRA is subject to challenge as not my deed, particularly if it's overbroad and capricious. Another case that I want to point out to you, which is going to be much more relevant to you, is this: Remax Rouge River Realty versus Gallagher. And let's go over the facts in the decision. Just interesting stuff, because you'd never really think about this, but it's quite important. Buyers were a couple. Only one of the purchaser's spouses signed the buyer agency agreement. The other entered into a different agreement of purchase and sale. And the other entered into an agreement of purchase and sale. Brokerage sues for commission, claiming that the spouse represented both parties. But the court said that only the husband signed the buyer agency agreement, and it was the wife who submitted the offer to property for purchase. And the court could not find that the wife was a party to the buyer agency agreement, nor could it find that the husband was a party to purchase the property. And as a result, and this is critical for you in your claiming your commissions, when assisting a buyer, brokers and agents should ensure that both spouses sign the buyer agency. It's a fascinating case. I don't hear too much about it. But if there is a buyer with knowledge that is looking to screw you and is married, this is a very easy way to do it if all you do is get one signature on the document, on the BRA. Does that make sense? I'm going to pause for a minute. That makes sense. Okay, good. All right. So we've talked about how you can lose your commission, but that's not the reason that I have, I guess, 6 of you here today. The reason you're here, and the reason you're watching this video afterwards, because Mark was silly enough to actually, being Jewish, I structured this on Easter and I didn't realize, I'm sorry, but regardless, if you're watching it, what if the non-signing party was registered on title, Tracy asks. That's irrelevant. How you take title is irrelevant. All that matters is if you enter into an agreement of purchase and sale pursuant to Section 2 of your agreements. So you would still get around it. But even if you didn't, if they were really looking to get around, they would just put one person on title and then do a title transfer. As their spouses, there'd be no tax consequences to that, nor would there be additional land transfer tax. So you could register on title as a separate event if you needed to, if you really wanted to be crystal sure. The point is, get both signatures on title. Okay, let's now talk about why it is you guys are here, how to keep your commission. So let's set the scene again, guys. Having just saved a baby from a burning building, lawyer is now back at his desk thinking what to do with the actual key to the city provided by the mayor. By the way, all of these are real events. This happens to me daily. Either I'm saving a cat or a baby. The mayor has me on speed dial. It's really something else. In walks a hardworking realtor looking agitated. Me, what can I do for you? The agent. Oh, it's just awful. Let me tell you my story. And by the way, if you guys think that you're any different than grandma and that you don't tell 4-hour stories before you get to your point, you are wrong. Regardless, yada, 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 given the facts of my story, my client is just awful, and now I want to be paid my commission. Interesting, say I. This is what we're going to do. So, I am assuming that there is no problem keeping your commission when a deal concludes, because they're all irrevocable directions and the lawyers aren't going to screw with commissions that way. And in the event that they do, there's a whole series of case law stating that they're not allowed to do so. By the way, if a lawyer ever says, I have directions from my client saying that the commissions are not to be paid over to the brokerage from my seller client, you should know that the lawyer themselves will be liable in that circumstance. Based on case law. It's actually quite fascinating, but that's not what I'm talking about here, because that never really happens. What does happen frequently is that deals fall apart due to the intentional or unintentional actions of either a seller or a buyer. And the real question is, well, I've worked really hard and I've constructed this agreement of purchase and sale. Can I claim commission regardless of the fact that the deal didn't close? Interesting. Well, let's talk about it. So, there are two things that you will immediately think about when we're addressing this issue. First is Section 2 of the Buyer Representation Agreement, and the second is Section 2 of the Listing Agreement, and you're familiar with both. It says that the buyer agrees to pay such commission as described above, even if a transaction contemplated by an agreement to purchase or lease, agreed to or accepted by the buyer or anyone on the buyer's behalf, is not completed, if such non-completion is owing or attributable to the buyer's default or neglect. So that's pretty simple. If you're acting for the buyer and the buyer somehow doesn't complete the deal, the buyer owes you commission. That's just what it says in the contract. You can sue in contract. And similarly, if you are the listing agent and you are acting for the seller and the seller chooses not to complete the deal for whatever reason, outside of a conditional period or something, but if it's a firm agreement and they just choose not to go forward, well, you have a contract with them through the listing agreement that says that you are owed that commission. So Section 2 kind of helps us with two of the primary areas that we need to have in order to sue for our commissions. And I don't really think that you guys are here doubting that. In fact, I think you're probably familiar with that. But what you are interested in are the two question marks here. What happens when you are acting for the cooperating brokerage and the seller defaults? Or similarly, what happens when you're acting for the selling brokerage and the buyer defaults, right? In those instances, you're not going to sue your client. That's ridiculous. They did nothing wrong. In fact, you probably have a good relationship with them and you have no claim. Remember, there's a concept called privity of contract. And privity of contract states that you can only sue those people with whom you have a direct relationship. You do not, as the cooperating brokerage, have a direct relationship with the seller. The listing agreement is signed, the buyer representation agreement is signed solely with the buyer. And when you are acting for the selling brokerage, you do not have a direct contractual relationship with the buyer. Your listing agreement is signed only with the seller. And so what you have is you have a privity of contract issue where before you were able to sue because you had a direct contract in this instance here and this instance here, you have no direct contract in these boxes. And so for the remainder of this time, I'm going to talk about what to do for these boxes. And the first thing I'm going to do is I'm going to deal with this one. When you act for the cooperating brokerage and the seller defaults. And I'm going to call your attention to MLS Rule 760. Granted, this is only for properties that are on MLS, not exclusives. But if you're using MLS in order to sell a property, there is a rule. It's a rule that very few agents know about. And it says this. It says, when the commission is not paid to the listing brokerage in accordance with the amount stated on the MLS agreement, the listing brokerage and the cooperating brokerage shall decide whether to pursue legal action or other action against the seller. Again, we're putting ourselves in the position of the cooperating brokerage and the seller defaults, just to remember. And here's the critical part. If the listing brokerage does not agree to pursue a claim as provided in the immediately preceding paragraph, and that happens often because the listing brokerage is the one that has the relationship with the defaulting party. And sometimes they're saying, hey, I'm ready to sell, I just want a higher price, and you don't want to have to sue them or anything else. You just want to move on and get the deal. The cooperating brokerage, which has now been screwed out of their deal or their commission, may, within 30 days of the closing of this transaction, by written notice to the listing brokerage, require the listing brokerage to either A, make immediate payment to the cooperating brokerage of the full amount of commission payable to the cooperating brokerage, or B, take such steps as are necessary for the cooperating brokerage to pursue a claim for the commission provided. So remember, it is the case that there exists in this scenario a contract between the selling brokerage and the seller. But the selling brokerage may not want to sue the seller. In this instance, the cooperating brokerage doesn't have the same incentive. After all, the seller is defaulting on this. And as a result, the cooperating brokerage pursuant to the MLS Rule 760 can force the selling brokerage to sue the seller on the cooperating brokerage's behalf, provided they engage MLS Rule 760 within 30 days of the default. And accordingly, we are now able to further fill in our chart. We're now able to say, okay, I know what happens if the buyer defaults and I'm acting for the cooperating brokerage. I know what happens if the seller defaults and I'm acting for the selling brokerage. I know what happens if the seller defaults under an MLS listing and I am operating for the cooperating brokerage. I know all these things, but I still don't know these two. And to that end, we're now going to approach those two. So this is the untested waters, but I'm going to give you my legal analysis. So let's talk about negligence. Negligence is a tort. A tort is just general common law. Sorry guys, can I just ask you all to, I think someone, oh Peter, I think it's you. There we go, okay. There was just background noise there. Negligence is what happens when someone does not live up to the expected duty of care that they have. And it applies to people based on their circumstance and based on who they are. So as an example, a realtor has to live up to the standard of care of a realtor. The seller has to live up to the standard of care of someone who engages in an agreement of purchase and sale. The buyer, similarly. And what are those standards? Well, the standard of care is that you treat your contracts seriously and abide by the terms. This isn't rocket science. This is just basic understanding of law. And as a result, they've entered into a contract where there's a duty of care owing to people more than whom they have contracted with. There is a duty of care to all the people who are reliant on that going forward. Accordingly, let's go, there's a second step. Let's not go to accordingly yet. The second step of a negligence claim is proving that someone has fallen below the appropriate standard of care. So in this instance, if the appropriate standard of care is that you abide by the terms of a contract and close, failing to close is someone falling below the appropriate standard of care. And last, that the activity results in some harm to a third party that is foreseeable. I didn't put that in there, but foreseeable is a critical word in negligence. Is it foreseeable that agents who have brought this deal together will be out their commissions? Definitely so. So the real question is, can we claim that a duty of care is owing between the clients and the agents with whom they are not in contract, insofar as we all have duties of care when we sign contracts? And if so, a negligent claim may be asserted. Now, I haven't found cases where this has been asserted yet, but in Toronto, we're at a point now where commissions can sometimes be close to $100,000. And I can assure you that at some point, someone is going to take a stab at this. And when they do, it will be very interesting to see how the courts come down. My take on things is that if it is exclusive and the seller defaults and you're acting for a cooperating agent, a negligence claim can be made. Certainly in small claims court, why not give it a shot? $35,000 there, which covers most commissions. When acting for a selling brokerage, if the buyer defaults, a negligence claim. And in getting both of those factors, suddenly we're able to fill out the chart in a beautiful manner. We know that we have direct contractual recourse here and here. We know that under MLS Rule, pursuant to our governing bodies, we have recourse here, which allows us to partake in the contract here, forcing the seller to sue the seller's client. And last, we know that we have tortious claims in negligence here, or at least good grounds to claim tortious claims in negligence. And I'm waiting for that case to come out. Now let's talk about one final aspect here and one final case before we wrap up and I take questions. And that is the mutual release. The mutual release is a document which, when deals go south, allow for parties to move on their own. There is no requirement whatsoever that the agents sign a mutual release in order to give effect to the mutual release. That is to say, a buyer and seller can agree to a mutual release, generally with the return of a deposit in one or two areas, but the agents do not need to sign that to make it valid. Yes, there are spaces for the agents to sign because the hope is that this is a comprehensive mutual release that governs everyone. But in the event that they don't sign, then the agents maintain their claims as against the buyer or seller or whoever defaulted, such that they can then pursue this. And the seller and the buyer know that the recourse that they have against each other are at an end. And given that the agent's commissions are like $20,000 or $30,000, it may very well be that a buyer and seller on, say, $1 million property are ready to just sign the mutual release, move on, and then just deal with the $25,000 in small claims court and see where that lies. But there's no need that you have to sign the mutual release to allow the buyer and seller to move on with their life. Yes, they may still be in court with you, but it will not affect the property. Does that make sense? I'm going to assume so, because I'm not hearing back from you. It's hard when you don't get an audience here. Oh, someone said yes. All right, good. Let's take a look at one last case, which I don't remember, so let me just quickly see. Oh, one last nice case that I found, which answers the question that you've all had in your head for 100 years. And what happened here in Raylert Realty versus Foddy is that a client signed a listing agreement with the brokerage, and the listing price was not a strategy to induce higher offers, which is often what happens in Toronto. That's what the evidence was that was induced. At the time that they signed this listing agreement, it was the case on the evidence presented to the court that they were ready to accept an agreement if it was brought in on those terms. And if you take a look at what Section 2 of the agreement says, it says, in consideration of the listing brokerage listing the property, the seller agrees to pay the listing brokerage a commission of X for any valid offer to purchase the property from any source whatsoever obtained during the listing period. And so what happened here was Foddy got an unconditional offer for his exact purchase price as stated in the listing agreement. And then he rejected it and said, I want more. And the brokerage sued for commission. And the court said, thank you very much. We're going to award commission. Now, this would not, the reason that this is not something you should drill into your head and say, aha, I can get my commission when I get an agreement, is because facts in this are everything. If the strategy of someone who's listing a property is to underprice, then simply getting that price does not obligate someone to pay commission, because a court will say, acting reasonably, it was almost a non-es factum. This is my own personal opinion, but it's almost a non-es factum issue. It was never intended by the parties that that's where they would end up. And accordingly, enforcing that is really a hammer, particularly given that it's the agent that made the contract. After all, everyone must act in good faith. Remember Basson and Harnu, which is the Supreme Court decision. And in asserting this contract and forcing someone to actually pay commission because they got something that everyone acknowledged was going to be under where they thought they would end up, is it really good faith of the agents to force that forward? This is not something that's been decided by the courts. I'm just telling you how the evidence works in the courts. So don't use this as a sword, but you can use it as a shield. You can use it to, if you've worked your arse off for a year or two to get an offer in, and the client has said, no, I'm only accepting this price, I'm only accepting this price, I'm only signing a listing at this price, and suddenly it comes and it's unconditional, and then they say, no, you know what, it's not enough. Well, you have the right to still claim commission pursuant to this lovely case. And so that, people, is where indeed I'm going to end today. I'm now going to open it up to questions. And of course, I'll post this online. And if anyone has any questions, having watched this post-live event, please write it in and we'll address those as well. What questions do you guys have for me?
I think this was pretty clear, Mark. Thank you very much. If an agent, just curious, really, just nothing but curiosity, if an agent wants to pursue a legal action versus a client for commissions or the opposing side, I understand they might come to you for advice, but then do you forward them to a litigation lawyer, or is it something you handle yourself?
No, I don't handle litigation. My brother's law firm does, so I usually just transfer it over there. It depends how serious the issue is. Look, real estate lawyers are not known to be litigators. It is not where I spend my time. So what we do generally as your real estate counsel is we set you up knowing what the law is. We set you up with the correspondence and the evidence that you're going to require when you go over to a real estate litigator. Or just a general commercial litigator, who then takes your case through. Of course, if it's small claims, then paralegals are really the best options, just because they keep costs down. But all of them will require the evidence that a good real estate lawyer will induce. So to answer your question, no, I don't do litigation anymore. Any other questions, guys?
I have a question.
Yeah.
I've been really curious in this regarding this phenomenon about grossly underlisting properties in order to obtain the highest amount of offers.
Yep.
And so what I'm curious about is if an agent does grossly underprice a listing, how is that not considered to be deceptive or misleading to the public when there was no intention of ever selling the property at the offered price?
Okay, well, that's actually an excellent question. And it's going to cause me to think on my feet. So let's first put this into the proper category of law. In real estate, as with all advertisements, it's a bit strange to say this because you wouldn't think it based on the name of the act, but it all falls under the federal guidelines of the Competition Act. It is the Competition Act that deals with misleading advertising. And I guess the question is there any difference between putting bids welcome and putting $9.99? I'm not certain how unfamiliar people who actually bring bids on an offer date are. You know, like there's one brokerage in my CO2 area that lists every property they get at $9.99, despite the fact that property values, as long as the property value will sell for less than $2 million, they put it at $9.99, and they just let the market determine. Everyone knows that $9.99 is not real, in the same way that they know that if you say bids welcome, you're not going to accept $1. I'm not sure that allowing for the market to determine a price is inherently problematic. But your question is different, Tracy. Your question is it anti the is there a violation of the Competition Act if in fact you are putting out a misleading advertisement of price? And with your permission, I'm just pulling up the Competition Act. Misleading ads. I just want to see what I can find online quickly. Okay, hold on for a second. It's an interesting question. I prefer to actually look into this a bit further. So it is Section 52 of the Competition Act, and it's a criminal provision. And it says that parties are prohibited from knowingly or recklessly making or permitting the making of representations to the public in any form whatsoever that's false or misleading in a material respect. And under this provision, it's not necessary to demonstrate that any person was deceived or misled. That any member of public to whom the representation was made within Canada, yada, yada, yada. I don't have a quick answer on this. I would like to think about it. I would like to get back to you, but I will get back to you. It's just something which is an interesting question that I think requires a bit of nuance. And rather than blather on and give you what I think might be a string of words that constitutes some form of sentence, I prefer to give you something that is a bit better thought out than that. So maybe what I'll do is I'll take a look at it when I post this video and just put a comment in on that section if you do not mind. And it will be pertaining to Section 52.
I think there could be two parts to this, in that, you know, there's a seller that could do that, but then there's also realtors engaging in a deceptive practice.
Again, I really have to take a look at how the Competition Act comes down on this. And just rather than wasting everyone's time, I don't have a quick answer. I just need to take a look. I'm hearing what you're saying. I'm acknowledging it. I just need to figure it out. So yeah, please look to the comments.
Thank you.
Good question. Great question. Anything else? Okay. Well, guys, thank you so much. I know it's ironic to be wishing you all a happy Easter after I've chosen to do this directly on Easter Sunday, and I'm sorry for that. I'm not sure that the people who are hearing me live say happy Easter are going to care all that much, because otherwise they'd be somewhere else. But regardless, if you're watching this after, happy Easter, happy Passover for those people, and happy holidays for everyone else. I hope COVID is treating everyone well. And just as a bit of a positive note, I would tell you that I, like everyone else, am monitoring what's happening out there with COVID, and I remain incredibly proud of this country, of our federal leaders, of our provincial leaders. I think regardless of political affiliation, we are handling this well as a country. We're coming together. And if there is going to be an end to this, it's going to be because people have acted responsibly at all levels and all individuals. And I thank you all for taking that seriously, staying indoors and attending courses like this. And I'm wishing that we get back to work in normalcy in the coming months due to all of our diligence. So thank you very much, guys.
Thank you.